Chester Brown, sorry to have to rush you. I'm sure it's just the tip of the iceberg. We'll now proceed next to the second speaker, Ms. Harpreet Kaur, with her title of the papers, Clash of Bilateralism and Regionalism in International Investment Agreements of ASEAN Member States. What have we overlooked? Thank you.
Thank you. Asking lawyers to keep within very tight time frames, I applaud the organizers on taking on this Herculean task. Thank you, Chi Kwan. It's my pleasure to be here, and I thank the organizers for the opportunity to address you this afternoon on the subject of overlapping investment treaty protections and why an investor may approach strategically the question of which amongst multiple international investment agreements between the same state parties it chooses to initiate investor-state arbitration under. First, how does this issue come about? On this slide, I've given you a snapshot of some of the investment treaty relationships existing or that are on the horizon for ASEAN. You can already begin to see the overlap. Same state parties, more than one international investment agreement governing. For example, moving wider than ASEAN, the central red circle, you see ASEAN plus one agreements. Agreements ASEAN has concluded with trading partners such as Japan and China. But there are also existing bilateral relationships between ASEAN member states and these plus one trading partners. For example, Singapore has an existing bilateral investment treaty with China. Moving even wider, you see two larger termed mega-regional agreements that are on the horizon, the Trans-Pacific Partnership and the Regional Comprehensive Economic Partnership, terms that have been thrown around this morning as well. Several ASEAN plus one states, such as Japan and Australia, will be party to the TPP, as will several ASEAN member states, such as Singapore and Vietnam, another layer. RCEP will consist of ASEAN member states and all of its plus one trading partners. But RCEP will not, they say, replace the existing ASEAN plus one agreements in force. I quote from its guiding principles. The ASEAN plus one FTAs and the bilateral plurilateral FTAs between and among participating countries will continue to exist, and no provision in the RCEP will detract from their terms. What this all means is that you have layer over added layer of agreements that may govern the same investor-state relationship, and that overlap in the menu of investor protections offered. The ISDS provision, however, and the jurisdiction of the tribunal over a dispute arising under one agreement is limited to that agreement. It does not immediately extend to the other agreement, with the exception perhaps of the most favored nation provision, which this session is not concerned with, and the investor may in effect choose which agreement in its view is more favorable to its claim and proceed under it to arbitration, or perhaps more exceptionally, initiate two separate arbitrations under two agreements between the same state parties regarding the same measure and the same alleged breaches. What does this all mean? Let's take a specific example and the comparators of my presentation. I looked at an ASEAN plus one agreement versus a bilateral FTA, and an ASEAN agreement versus an intra-ASEAN BIT. In the interest of time, I'm going to focus on the first of these sets of comparators, and they are these agreements. On this slide, you see three agreements, all relevant to the investor-state relationship at international law between Singapore and China. There is the Singapore-China BIT of 1986, the investment agreement of the ASEAN-China Free Trade Area of 2010, and the investment chapter of the China-Singapore FTA of 2009. The investment chapter of the China-Singapore FTA on the far right incorporates the ASEAN-China investment agreement to the extent compatible with it. So the comparison is really between the Sing-China BIT and the ASEAN-China investment agreement. Now take a Singapore investor in China alleging breach of fair and equitable treatment and expropriation. What happens? Beginning with FET, immediately looking at the Sing-China BIT and the ASEAN-China BIT, you see a difference in the content of the obligation. What are the specific differences? I've set them out in this table. The ASEAN-China agreement refers to fair and equitable treatment and full protection and security, terms that Chester has introduced to you. The Singh-China Agreement, however, uses FET and protection, combines the two elements, perhaps. This is all subject to argument by very creative counsel. And it tags on the phrase, in accordance with this agreement. The ASEAN-China version is arguably clearer and from the state's perspective tighter on language. FET and protection together may be interpreted arguably more broadly than FET and separately full protection and security. And it's unclear what in accordance with this agreement in the Singh-China BIT means. On one interpretation, it means that observance of FET requires observance of other substantive obligations under the BIT. This means, unlike the case of the ASEAN-China Agreement, breaches of other obligations of the Singh-China BIT may be significant in the tribunal's evaluation of whether fair and equitable treatment has been breached. In ASEAN-China, if you look the last row, breach of another provision of the same agreement or of a separate international investment agreement shall not establish that there has been a breach of BIT. It narrows the obligation, it respects the remit of the tribunal's evaluation. Staying on this point, what do these agreements generally say about how they relate to other international agreements? In ASEAN-China, it provides that nothing in the ASEAN-China agreement shall derogate from the existing rights and obligations of a party under any other international agreement. This suggests that as far as the ASEAN-China agreement is concerned and a tribunal constituted on ISDS provision under it, the obligations under the ASEAN-China agreement coexist with the obligations under the Singh-China BIT. Similarly, Article 15 of the Singh-China BIT. Thus, putting aside the exclusive jurisdiction of a tribunal under each agreement, the agreements themselves do not attempt to cancel out or override another. So they coexist. Sorry, closer? Okay. Ooh. Now you're really going to hear me. Returning to FET and turning to what kind of measures do not fall under the obligation as between the two agreements. In Singh-China, you have one general provision spelling out the carve-outs. In ASEAN-China, there are two articles, general exceptions, security exceptions, and they span about 3 pages. Again, immediately you see a difference. But breaking down what they exclude. First, taxation measures, and I'll return to that when I address expropriation. Second, the general approach to the carve-outs. See the second row. ASEAN-China refers to ensuring the measure is not applied in an arbitrary or discriminatory manner. Singh-China, in contrast, is more liberal. It uses the phrases, shall not in any way limit the right of the state, or apply restrictions of any kind. Going down the table, ASEAN-China excludes measures necessary to protect public morals or maintain public order. Singh-China BIT does not provide this. There is a question of whether this notion of public morals and maintaining public order falls within essential security interests, which Singh-China BIT does provide for. However, again, ASEAN-China has a separate provision entirely devoted to that, the security exceptions provision. From an investor's perspective, which one provides you with more maneuverability? From a state's perspective, which one channels the tribunal's decision-making power more effectively? And can the state control which agreement the investor proceeds under? The same issues persist in the obligation not to expropriate. First, whether it extends beyond direct to indirect expropriation. It's a clear yes in the Singh-China BIT. It uses the phrase other measures having effect equivalent to. In ASEAN-China, it is less clear. It uses the phrase other similar measures. Question is whether they are one and the same. I find that arbitrations tend to be about disputes where it just so happens that the factual matrix can exploit that one gray area that treaty negotiators might not have contemplated. So again, it might be a small difference, but in that one case where it's a 1.5 billion claim, it makes all the difference. The analysis is a little different if you look at the comparator I touched on, that of the ASEAN Comprehensive Investment Agreement, or ACIA, referred to this morning, versus a BIT between two ASEAN member states, where the approach to expropriation is much like what you find in the Sing-China BIT. The ACIA has an explanatory annex, Annex 2, which, aside from listing the factors the tribunal should consider, defines explicitly what direct expropriation is as compared to what indirect expropriation is. Thus, it leaves no doubt. It also directs the tribunal to conduct a case-by-case, fact-based inquiry to determine whether a measure is indirectly expropriatory, considering, among other factors, its economic impact. Returning to the Sing-China BIT and even the ASEAN-China agreement, you do not find this kind of explanation or annex. From the state's perspective, this is the approach that they would like the tribunal to take into account. But what should a tribunal facing a provision without the assistance of this explanatory annex do when it knows there is another agreement, same subject matter, same state parties, same alleged breaches, which does express the state's party's intention in this way, but its jurisdiction does not extend that far? Between Sing-China and ASEAN-China, the conditions the state must comply with in a lawful expropriation are similar, and I will not dwell on this. On the matter of carve-outs for expropriation, it overlaps with those I identified to fair and equitable treatment, but one significant difference is in the context of taxation measures. Both agreements exclude taxation measures from their coverage. The ASEAN-China agreement, however, excludes it from all but the obligation not to expropriate and preserves the investor's right to invoke the state's consent to submit such a claim to ISDS. Thus, returning to the Singapore investor in China scenario, if the measure that you are upset with is a tax, the ASEAN-China agreement provides you an avenue for dispute resolution recourse that the Sing-China agreement does not. And that brings me quite neatly to the preconditions to invoking the state's consent to investor-state arbitration under these agreements. These preconditions, they determine the investor's right of access to ISDS. Do not fulfill these preconditions, arbitration agreement does not come into effect. The table shows a marked difference between the conditions precedent set out in the Sing-China BIT and the ASEAN-China investment agreement. One is in the requirement in the ASEAN-China conditions precedent, and that's found, fourth row down, that the investor, in its notice of intent to arbitrate, waives the right to initiate or continue any proceedings before any of the other dispute settlement fora. Usually there's more than one ISDS forum specified in the ISDS provision of an investment agreement regarding the same dispute. So this eliminates duplicative proceedings under the same agreement. You can only submit it to one forum. If the investor fails to comply, the tribunal can use the waiver, and the fact that the state's consent, and here we look at row number 2, where it says the state's consent shall be conditional upon these conditions being satisfied, to find that the consent to arbitrate has not been perfected. This does not, however, eliminate proceedings by, for example, coming back to the scenario of the Singapore investor in China, and it's not a taxation measure, so the measures are arbitral under both agreements equally. If the Singapore investor proceeds under either or both ASEAN-China and the Sing-China BIT for alleged breach of the expropriation provision, the tribunal under one agreement cannot stretch its arm to the other and seek to join the two separate arbitral proceedings under two separate investment agreements. Despite the commonality of parties, measure, and breach, neither can it invoke the provisions of the other international investment agreement to interpret the provisions of this agreement over which it has jurisdiction. So this reinforces the capacity of investors to be strategic about which agreement to better proceed under in dispute settlement, or to put it bluntly, get two kicks of the can. In conclusion, and I hope I'm within time, how rare. In conclusion, focusing on point 1 of this slide only, the approach in the Vienna Convention on the Law of Treaties, and this is a treaty that sets out general principles of treaty interpretation. The approach to treaties between the same parties over the same subject matter is that the latter in time prevails. As noted above, however, investment treaties tend to preserve the obligations under other agreements, and here I would reiterate the language, nothing in this agreement shall derogate from obligations under another agreement. The question is whether this notion, we shall not derogate, was it intended to apply in the event of overlapping treaty protection? And if this was not contemplated, and so not intended, and if this provision is removed from international investment agreements, as far as investment treaty protection is concerned, how would the latter in time prevailed approach work in practice? Is it enough to refer to it in the investment agreement for the tribunal to find it cannot adjudicate on the basis of the obligations in it, if the older agreement, in favor of the more recent agreement? Taking a step back from that, one of the other VCLT principles is that any relevant rules of international law applicable in the relations between the parties may be taken into account in interpreting a treaty provision. This is Article 31, subsection 3. Could this be used when, say, one FET articulation is more vague than another? Or does this fall foul of the notion that each agreement stands on its own in that it reflects a certain collection of state parties' intention? These are difficult questions. I wish I could answer them, but I would contend that time is ripe for treaty negotiators to confront them. With that, with 2 seconds to go, I come to the end of my presentation, and I thank you for your attention. I look forward to any questions that you may have. Thank you very much.
Thank you.